she's talking about when she says the jury did not unanimously believe that Dr. Konig had an intent to kill his wife. Do we really think she was talking about when like deliberations started and not at the end? I mean, I did not believe that he had an intent to kill his wife during the incident, and I believed that he was not guilty of attempted murder. Do we really believe that she's talking about something other than what we know she's talking about, which is during the deliberations? So, I mean, that argument should not carry much weight. Again, this thing that somehow getting this right and enforcing his constitutional rights to a unanimous jury verdict is going to have a chilling effect on jurors in the future. I don't see how that would be the case. So, one second, Your Honor. And again, like I hope the court, I'm sure the court understands this. I don't know how to be more clear about it. I'm not asking you to get into the why they reached this decision, right? When the foreperson says, I did not believe he had an intent to kill, I do not believe he was not guilty. I'm not asking you to consider why she felt that way. Her deliberative process in getting to that conclusion. I'm not asking you to consider that. That's what 606 says we cannot. They wouldn't use the word processes or process if we couldn't consider the result. We poll jurors as to the result. So obviously we're allowed to ask them about the result and consider it. What would you, Your Honor, think of it this way. Think of it this way. If you polled the jury and 6 said, no, I don't think he was guilty during the poll, what would you do? You would send them back to deliberate. You wouldn't be like, okay, well, we're not going to get into your mental deliberative processes and your result, and we're going to, that's the secrecy of your deliberations, but we'll take the verdict and lock this guy up for the rest of his life. Of course not. So obviously the polling process demonstrates you can look at the objective end result and consider it. And I ask you to think about that. Those two examples. If you did a poll and it was not unanimous, what would you do? And if there was a verdict and a juror walked out and said to the camera, well, we found him guilty, but 6 of us really at the end thought he was not guilty, but whatever, I have a hard time believing that Your Honor or our appellate courts would just say, hey, secrecy, we don't want to, that's up to them. No, it's not up to them. It's not up to them as to whether they follow the law or not. And so again, we're asking you to get this correct now. There is enough here to rule that way without doing inquiry or whatever. They could have done that. They have investigators. If they really wanted to do that and meet their burden, they could have gone out and talked to every single juror. They didn't. And so we're asking that you grant the motion today and set the case for our second trial. Thank you.
Counsel, I understand and appreciate the arguments that you made in the application of 606B to what might have been said out into the media and what's in the moving papers that was submitted to the court. At this point in time, I am concerned about the exception to the bar that jurors can be examined on the existence of outside influence. This is brought up by the defense in the Remmer decision, and Remmer is treated, examined, and used by the Hawaii Supreme Court on this issue. Assuming the prima facie case for outside communication has been made, right, the Supreme Court of Hawaii directs the trial court by saying where the existence of an outside influence, such as juror misconduct, is brought to the attention of the trial court, the court must ascertain the extent of the influence and then in its sound discretion take appropriate measures to assure a fair trial. This is State v. Chin, 135 Hawaii, 437, page 439. It's a 2015 case, and it cites Remmer v. United States in its reasoning. And it goes on to say that the outside influence need not touch directly on the guilt or innocence of the defendant to trigger the presumption of prejudice. It is enough that during the crucial period of jury deliberations, there was a private communication bearing even remotely on the trial or the jury's function in it. And I understand the argument as to who bears the burden and who needs to counter it, but here what the Supreme Court is telling this court, that the court must ascertain the extent of the influence. So the burden is on me, right? And as abhorrent as this sounds, the way I read this case is telling me that I have to do what I really don't want to do and bring in these jurors and ask whether or not they were tainted by outside influence. And as much as I don't want to do that, the case law is must. The court must ascertain the extent. So, counsel, as much as you might want a ruling today, I think I have to do that. Does anybody object, or do you think I'm misreading the case?
Well, our position, Your Honor, is there is enough here to grant the motion. If there's enough here to grant the motion without that inquiry, because we made a prima facie showing, and the state has not met its burden to overcome the presumptive prejudice. So there's enough here. It's not for Your Honor to go through this exercise to try and save the state's, the verdict. And I mean that respectfully. So here's what I mean. I would. There's enough here to grant it. There's enough here to grant it. If you were, you can grant it without further inquiry. I don't think you can deny it without further inquiry, but you can grant it without further inquiry. And here's the problem why it should be granted without further inquiry. Here's why it should be. We're here on, what is today, August 14th? This motion was filed on May 15th. Okay, the trial ended, I think, in April, right? So May, June, July. Well, here we are over 4 months later.
So let me pose the question slightly differently. What if I disagree with defendant's interpretation of 606B and the mental processes of the jury?
Then you would still grant it as to the texting issue, following the cases that we cited.
Well, Chin requires me, right, to ascertain the extent of influence, because just because there's contact doesn't mean that it's a bad verdict.
Well, I would disagree. That goes against the cases that we cited that suggest that any outside contact is presumptively prejudicial. So we can't ignore that. We can't ignore that. So we're not starting on even footing here. We're starting on the presumption that it's prejudicial. And that's, again, State versus Furutani, 76 Hawaii 172. And the point, again, we would be ignoring that. And what do we do with the fact that the state has not met that burden and done anything?
Well, let's step back. If we take for face value Exhibit D, there's contact, but we don't know if there's influence, right? And
there was communication. And that's what the cases talk about. Communication with jurors are presumptively prejudicial. It doesn't say influence with jurors are presumptively prejudicial. And you cited, thankfully, some other cases that suggest that. It's not a harmless, hey, what'd you guys eat for lunch in the verdict room? It's presumptive. The contact, the communication itself is presumptively prejudicial.